There was a moment, somewhere in my third year on this bench, when I started to wonder whether the institution I served was still doing what I had believed it did. Not in the legal sense. I don't mean procedurally. I mean in the deeper sense. Whether justice, as I understood it when I raised my right hand and took the oath, still lived inside the day-to-day reality of the work. Whether the gap between what the law required and what a situation genuinely demanded had in some cases grown so wide that bridging it was no longer possible. Whether the robe and the bench and the formal record were in service of something real or something that had drifted, slowly, through thousands of small decisions made by thousands of people over decades, away from the reason any of it was built. I was carrying that question the morning this case file arrived on my desk. I am going to tell you about this case carefully. Not because it is a simple story, it is not, but because the weight of it is the point. If you come to this story looking only for the resolution, you will miss everything that makes the resolution mean what it means. My name is Isaiah Webb. 4 years on the federal bench in Chicago. I took an oath to uphold the law. This is the case that showed me what that oath is actually for. Subscribe to this channel, not for the resolution, but for the weight. Because what you are about to feel is what justice is supposed to feel like. I'm going to tell you what happened in that room. Not the case, the decision. There's a difference. My daughter Amara is 9 years old. She asks questions without shame and without the defensive posture that adults develop after years of being judged for not already knowing the answer. When she was 7, she asked me, "Why do rules stay even when following them makes things worse?" I told her what I believe to be true, that rules are an attempt to see the future before it arrives, and they cannot always get it exactly right for every specific situation, and that sometimes the hardest thing about being someone who upholds rules is the capacity to sit with the distance between what the rule says and what the situation actually needs. She thought about this for a long moment. She is not a child who responds immediately to complex answers. Then she said, "But who decides when the distance is too big?" I told her, "Sometimes that is what a judge is for." This is that story. Marcus arrived in my courtroom on a Thursday morning in November. He was 14 years old. He had been referred by a district magistrate following a citation for shoplifting at a drugstore, a Walgreens 11 blocks from the apartment where he lived on the south side. The dollar amount was $23.47. The items: 1 loaf of bread, 1 jar of peanut butter, 1 quart of whole milk, and 1 container of powdered infant formula. When the store security officer stopped him at the door, Marcus had not run. He had stood still, holding the basket. When the officer asked him to explain what he had done, he did not claim he had forgotten to pay. He did not say the products had been put in the basket by mistake. He said, "My brother needs to eat." His brother was Elijah. Elijah was 2 years old. I had the case file on my desk the evening before the hearing. I read everything before I enter a courtroom. I have done this from my first day on this bench, and I will do it until my last. I read the citation. I read the social services intake note from the night of Marcus's arrest. I read the case summary prepared by the magistrate's clerk. Marcus Dion Thompson, age 14. Mother deceased 8 months prior. Cardiac event confirmed, age 38. Father, identity unknown, never present in the home. No surviving legal guardian. No open DCFS case. No active foster placement. Subject has been identified as the primary caregiver of a sibling, Elijah Marcus Thompson, age 2. School attendance, irregular but not absent. His teachers knew him by name and had submitted the attendance records voluntarily. I put the file down and sat with it for a while. Then I picked it up and read it again. I need you to understand what the law required of me in this situation, because understanding what the law required is the only way to understand what the decision actually cost. And the cost is the whole point of this story. The law required a response to the offense. A theft had occurred. $23.47 of merchandise had been removed from a commercial establishment without payment. The store's loss was real. The state's interest in deterrence was real. The procedural record was real. For a first-time juvenile property offense of this dollar amount, the standard disposition in this jurisdiction was a fine in the range of $50 to $200, with the option of a community service alternative and the possibility of diversion to a youth intervention program, subject to the court's assessment of the circumstances. Marcus Thompson did not have $50. This is not a legal assumption. It is an evident fact from the record. He did not have $23.47 or he would not have been in that store holding a basket of bread and peanut butter and formula at the age of 14, alone, responsible for a 2-year-old. The law did not make exceptions for the reason a person had taken something. The law addressed the taking. The reason was a mitigating circumstance, a significant one, and I would consider it, but the taking was the taking, and the record would reflect it regardless of what I did with the mitigation. This is what the weight is, not the sentiment. I want to be very clear that I am not describing sentiment. I am describing the specific, concrete recognition that the law is asking me to do a defined thing in a defined situation. And the defined situation is a 14-year-old orphan, the sole caretaker of a 2-year-old, stole food. And the law's minimum response to that is a fine. I thought about my oath. I have thought about my oath more in 4 years on this bench than I expected to think about it across my entire career. I do not mean the words of it. I mean the thing the words are trying to name, the obligation that the words are pointing toward. The oath asks me to uphold the law and to administer justice without respect to persons, and to do equal right to the poor and to the rich. Those 4 phrases do not mean the same thing, and holding all 4 of them together at the same time in the same case on the same Thursday morning is not a simple task. Equal right to the poor and to the rich does not mean identical outcomes regardless of circumstance. It means the same access to the law's protections, the same standing before the court, the same quality of attention from the person in this chair. It means Marcus Thompson deserves the full attention and consideration of this court, not a shortened proceeding, not a dismissal without engagement, not a result that bypasses what he is owed because his situation is complicated. It means I see him. Marcus walked into the courtroom at 9:15 on a Thursday morning. He came with a public defender named Elena Reyes, 29 years old, 3 years in practice, the kind of lawyer who has not yet learned to keep the fire separate from the work. She was carrying a file that she had clearly spent time with. She had organized her materials. She knew this case. Marcus sat next to her in a gray sweatshirt that was a size too large. He was 14 but tall, broad in the shoulders in the way that means growth is still finishing the work it started. He held himself with a particular stillness that I have seen before in young people who have learned, before they should have had to, that adult spaces require a kind of controlled presence. He was not aggressive. He was not defiant. He was contained. The way people are contained when they have been containing themselves for a long time, and it has become their resting state. His hands were on the table, loosely folded. When I entered and the room came to order, he looked up once. I want to be careful about how I describe what I saw when he looked up, because I am not a person who converts observations into performance, and I am not doing that now. What I saw was a person, not a citation, not a file number, not the sum of his circumstances, though his circumstances were substantial. A 14-year-old person who had walked into a drugstore with a basket and had taken what a 2-year-old needed and had not run when caught and had told the truth when asked. I saw him clearly. Elena Reyes presented the mitigating circumstances. She was methodical and honest and restrained in a way that served her client better than theatrics would have. She presented the timeline. Marcus's mother, Diane Thompson, had died 8 months prior. There was no father in the record. No legal guardian had been identified in the 8 months since the death. The DCFS case had been opened, but was listed as pending, meaning no placement, no active worker assigned, no formal support structure in place. For 8 months, Marcus had been managing what needed to be managed. Rent paid late but paid. Elijah fed and dressed and kept away from services that might separate them. She submitted a letter from Marcus's school social worker, a woman named Brenda Okafor, who wrote with specific and careful language about what she had observed in Marcus over those 8 months, how he came to school prepared, how he was present in his classes when he came, how he had once asked her, quietly and without context, whether there was a way for a teenager to stay the legal guardian of a younger sibling. She had not followed up on that conversation the way she wished she had. Elena Reyes placed the grocery receipt on the record, the specific receipt from that Walgreens on that afternoon. Bread, peanut butter, milk, formula. The assistant state's attorney that morning was a young man named Kevin Park, thorough, careful, and visibly aware of what kind of case he was standing in. He did not press. He acknowledged the mitigating circumstances fully and on the record. He asked only that the court make a formal disposition so the record reflected the offense. He was doing his job, and he was doing it with the minimum force the situation could responsibly require. I respected that. I addressed Marcus directly. I said, "Marcus, I've read your file. I want to ask you a question, and I want you to answer it honestly, without worrying about what the answer means for this proceeding. I want to understand what happened, not the legal account, what actually happened that day." He looked up when I addressed him. He met my eyes, which not every adult can manage in that situation, and which a 14-year-old managing it on that morning deserved to have noticed. He said, "I had run out of formula. The WIC covers some of it, but it ran out, and I couldn't wait until Friday. Friday was when he gets paid, and I registered internally and immediately that he had a job. A 14-year-old, 8 months since his mother died, caring for a 2-year-old alone and working." I didn't interrupt. He said, "I knew it was wrong. I went in to get it anyway because I couldn't wait until Friday and he needed to eat." I asked who was with Elijah. He said, "My neighbor, Mrs. Patterson. She watches him when I have to go somewhere. She said she'd come today." I told him I needed a 10-minute recess. I went to my chambers. I sat at my desk and I thought about the oath. I thought about it in its full text, not as an abstraction. Equal right to the poor and to the rich. I thought about what the law permitted me to do and what it did not permit me to do. I thought about the fine, the minimum $50 that the statute required, and about the fact that Marcus Thompson did not have $50 and would not have $50 without working additional hours at whatever job he had found. Hours that would come from somewhere, and the somewhere would probably be the hours he spent on Elijah. I thought about the space that the law creates. The law is not inflexible. It is built with spaces, provisions, discretion, the authority of the person in this chair to apply the law's principles to a specific situation in the way the situation requires. The minimum fine was $50. I could set it at $50. I could provide a community service alternative that would give Marcus a path to resolution that did not require cash. I could order the DCFS referral with urgency language that might actually produce a timely response. These were all things the law permitted me to do. There was one more thing. I reached into my jacket pocket and found my wallet. I want to be precise about this, because precision here is the most honest thing I can offer. What I was about to do was not a judicial action. The law did not ask me to do it. The law had no provision for it. It was a personal decision. A decision made by a person who happened to be sitting in a judge's chair and who had $60 in his wallet and a clear view of what the situation required. A judge who confuses what the law asks with what he personally wants to do is a judge who will eventually do harm. I know this. I hold it carefully. What I was about to do was not from the bench. It was from the person underneath it. The distinction matters, and I was aware of it as I sat in my chambers with my hand on my wallet. I went back into the courtroom. I stated the disposition. The fine was set at $50, the minimum the statute required. I made available a community service alternative of 10 hours, which I strongly encourage Marcus to pursue as a formal resolution of the record. I ordered an emergency DCFS referral with a notation from the court that the family situation required immediate, not routine attention. I noted in the record that the mitigating circumstances were extraordinary, and that the court viewed this as a situation requiring individualized response at every level of the system. Then I looked at Marcus. I said, "Marcus, the fine in this case is $50. The record is going to reflect all of what Elena Reyes put before this court today. The record is going to reflect that you acted out of necessity for your brother, that you were forthcoming when you were stopped, and that you have no prior record of any kind. I want you to know something else, and this is not a legal statement. The system should have been with you 8 months ago. The failure that put you in that store is not a failure you made. It belongs to a set of institutions that are going to need to answer for it." I took the $60 out of my jacket pocket. I placed it on the edge of the bench. I said, "This is not from this court. This is from one person in this building making the decision that is available to him. $50 covers the fine. The other 10 is for tonight." The room was very quiet. I have been in rooms that were quiet because nothing was happening. That is a flat quiet. What I heard in that courtroom in that moment was a different kind of quiet. A room holding something that had just changed the shape of the air inside it. I looked at my bailiff, Arthur, who has been in that building for 22 years and has stood beside more proceedings than either of us could count. He looked at the money. He looked at me. He gave a single, slow nod. The nod of a person who has seen a great deal and recognizes, without needing to say so, when something is exactly right. Marcus looked at the money. He looked at it for a long moment. I could see him working through what had just happened. The same internal accounting I had done in chambers, except he was doing it in real time, at 14, in front of a full courtroom. He was deciding what it meant and what he was supposed to do with it. He said, "Yes, sir. Thank you." Elena Reyes had her hand over her mouth. She was maintaining her professional composure, and it was costing her something. I respected that too. I concluded the proceeding. On the drive home that night, I thought about Amara's question. Who decides when the distance is too big? I thought about what I had done and whether it was right. Not strategically, not in terms of how it would read or how anyone in that room had received it, but whether it was honest, whether it was what the situation required, whether it used the space the law creates for people paying attention, or whether it stepped outside that space in a way that would not hold up to my own scrutiny. I believe it was right. I hold that belief with specificity, not with comfort. I also believe it was incomplete, because $60 is not what Marcus Thompson needed. What Marcus Thompson needed was the system finding him in the week after his mother died, before 8 months passed with a 14-year-old managing a 2-year-old alone without resources. The $60 addressed the fine. The DCFS referral might address the larger failure. Might. The system that failed him was still the system. I was one person in it. I did what one person could do. That night I read my oath again, the actual text of it, not from memory, from the framed copy on my office wall at home. I do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as a judge under the Constitution and laws of the United States, so help me God. Equal right to the poor and to the rich. I read those words and I sat with them. I sit with them still. The question Amara asked, who decides when the distance is too big, does not have a rule for its answer. The answer is the person who is in the room, who is paying attention, who has the standing and the means to act. The answer is whoever is there seeing clearly and choosing to use what they have. I was there. I was seeing clearly. I had $60. The distance was not too big, but someone had to decide to cross it. I have not told this story in a public forum before this video. I tell it now because I have been asked, more than once and in more ways than one, what I believe justice is. And I find that every time I try to answer that question with a doctrine or a principle or a line from a textbook I used in law school, the answer comes out empty. It sounds right and it means nothing. The only answer I have that means something is this story. Justice is not the sentence. It is the presence in the room that sees the person and not just the case. It is the willingness to use the space the law creates, every inch of it, to do what the law was built to do, which is not to produce uniform outcomes, but to serve the dignity of every person who walks through that door, including the ones the system failed before they got there. Marcus Thompson walked through my door and I saw him. I hope the people responsible for him now, the DCFS caseworker, the school social worker, whoever is on that file today, have seen him with the same quality of attention. Subscribe to this channel, not because this story has a clean ending, it doesn't, not yet, and maybe not ever, but because the weight of it is real, and the weight is what justice actually feels like. A resolution without weight is sentiment. With weight, it is something a person can hold. In the comments below, I want to ask you one question. It is the same question Amara asked me. What would you have done if you were the judge? Not what you think the law required, not the procedurally correct answer. What you, specifically, would have done in that room, at that moment, with a 14-year-old in front of you and $60 in your pocket. Tell me. I will read every one.